Good day, Crime Talk aficionados. We have a recap, all the top stories throughout the week, conveniently located in one location. Thanks for watching. We'll see you next time. And remember, the Constitution matters.
All right, lawyer.
All right, ladies and gentlemen, we have a great show for you. Let's get to it. Now, we have brought you a lot of Bryan Kohberger stuff throughout the week. Friday, the court came out with new orders in that case. 3 to be exact. The orders for defendant's motion in limine regarding vague and undisclosed expert testimony. The order on the state's motion in limine regarding the text messages and 911 call, probably the most significant as it relates to trial issues. And then, of course, the order on the defense motion to strike the death penalty because Bryan Kohberger has autism. The judge shot that order down based upon Supreme Court case law, basically saying, hey, this guy, although he has autism spectrum disorder level 1, he can function just fine in life. He is not special in the sense that he has some sort of mental inability or mental capacity as the previous Supreme Court case law has defined, because in those previous Supreme Court case law, there's several fundamental principles. We don't impose the death penalty on people that have a mental disability. They used to call that the R word. And now, obviously, no one under the age of 18. Judge says, the guy was in a PhD program. Give me a break. He's very functioning. He knows what's going on. Denied. Now, the other big one, and I went over this word for word on Friday's show. So if you haven't seen it, I urge you to go there and watch it. All kinds of good details in there. But let's give you the brief summary today and then a little bit of comment about why is everybody picking on these roommates? All right. So like I said, chilling new details emerged in the Idaho murder case, a night that maybe could have changed everything. So in the new court order, the judge overseeing the Bryan Kohberger case has unveiled new details about the final hours of the 4 University of Idaho students who were brutally stabbed to death in their off-campus home. Now, drawing from the testimony and text messages of the 2 surviving roommates, the revelations paint a vivid picture of a night filled with ordinary decisions that nearly altered the course of a tragedy. On November 13th, 2022, Kaylee Gonzalez, Madison Mogan, Zana, some people tell me I'm mispronouncing it wrong, Zana Kernodle, Ethan Chapin were together in their home, unaware of what was going to unfold. About 2 a.m., the 4 were gathered in Kaylee's bedroom chatting and winding down after a night out. And Miss Kernodle was still out with her boyfriend, Ethan, at the time. In a moment that now feels fateful, the roommates debated heading back out for a late night snack at a food truck. One survivor, DM, even texted an Uber driver at 2:10 a.m. to check and see if they were available. Ultimately, they decided to stay in and just go to bed. A choice that sealed their fate in that house when a masked intruder struck just 2 hours later. Now, the court order issued by Judge Hippler details the events that followed. Around 4 a.m., DM was startled by strange noises and crying from the bathroom. Investigating, she caught a chilling glimpse of a figure dressed in black wearing a ski mask passing by her bedroom door. Panicked, she texted all 4 of her roommates, but only BF, the other surviving roommate, replied. And the 2 exchanged frantic messages, shaken by the lack of response from their friends and the sinister presence. The 2 exchanged frantic text messages, shaken by the lack of response from their friends and the sinister presence DM had witnessed. By 4:26 a.m., DM rushed to join BF in her downstairs bedroom for safety, and in her haste, she unknowingly passed Zana's lifeless body on the floor, mistaking her for being drunk. The 2 survivors locked themselves in BF's room, spending the next 8 hours desperately trying to contact their roommates, unaware of what had taken place just feet from them. It wasn't until almost noon that they made a 911 call, which later became a pivotal key piece of evidence in this case. Now, the details emerged as part of the court order granting prosecutors' request to admit selected text exchanges, testimony about the survivors' conversations, and the 911 call into evidence. Kohberger's defense team fought quite hard to exclude that evidence, arguing that it was inadmissible, but the judge ruled that portions, if not almost all of the portions constituted hearsay, and they wanted them to be barred. Anyway, Kohberger obviously is accused of murdering Miss Gonsalves, Miss Mogan, Miss Coronel, and Mr. Chapin, is facing a trial that begins on August 11th of this year there in Ada County after he successfully had a change of venue motion granted. That Mr. Kohberger's DNA was on a knife sheath, his cell phone location data, and surveillance footage of cars matching his vehicle link him to the crime. His defense, however, claims that he was just simply driving alone that night and denies any involvement. If convicted, obviously, Mr. Kohberger can ultimately face the ultimate punishment of the death penalty. So I want to talk a little bit about this tragedy. All right. I mean, this was a cold-blooded murder. 4 people are obviously dead. And we're going to give Bryan Kohberger the presumption of innocence. But as I've said, as a criminal defense attorney that has practiced for some 30 years doing almost exclusively criminal defense, that as a defense attorney, you have to look at your bad facts. And you can always usually tell what some of the bad facts are for the defense on what they're trying to keep out. Okay. Obviously here, the defense was really trying to keep out that DNA evidence. And we can go into, oh, it's not blood DNA evidence, it's touch DNA evidence. Ladies and gentlemen, it's DNA evidence. Okay. Your DNA wasn't on that knife sheath. Okay. Your DNA wasn't on that knife sheath button. Mine wasn't on there. Just coincidentally, by happenstance, Bryan Kohberger's knife sheath happened to be there. Now, for the people that say, oh my God, it must have been planted, I say that is a wonderful theory. How do you prove it? Show me who planted the evidence, okay? And I'm not saying he's guilty. I'm just saying you have to look at it. And if you're looking at this case from a defense perspective, that'd be great to say, obviously, it was planted by the one-armed man. But you have to be able to prove it. It doesn't matter what you think, what you believe. It only matters what you can prove. And what evidence do you have that somebody stole, allegedly, Bryan Kohberger's knife? Maybe it was never actually delivered to his house. It was intercepted via the mailing from Amazon, right? How do you prove that? There's no proof of that. But there's proof that he ordered the knife, the sheath, and a sharpener. We have information that he tried to get another one as well after the murders. Certainly goes to consciousness of guilt, does it not? Or, oh, I just happened to lost my knife one night when I was out walking in the woods looking at the stars. Let's get for real, ladies and gentlemen. A lot of people also want to bash on these roommates. You know what? Who's probably bashing these roommates hard enough is themselves. All right. First of all, they too could have been killed by the intruder that was in their home. Additionally, you don't think they probably second guess those decisions that they made that night, thinking I should have called somebody sooner? Absolutely. I'm sure they did. But we also know that they had been drinking. They were scared. They didn't know. This house has a reputation for a party house, people coming and going. They probably thought, she didn't think much of it other than, well, that was weird and creepy, right? Here's this guy. Okay, now I'm freaked out. Nobody else is answering. Okay. Or do you think, okay, I'm a college kid. Do I call the police, at this very moment? It could be some weird dude in the house. I don't know. They'll explain it on the witness stand. And if it's not to the satisfaction of the jury, that's it. But for these people that are out there, I've actually seen people say that, well, these roommates must have had some involvement of it. You may not like their kind of looking back hindsight. Well, I would never have done this under this circumstance. I would have called the police immediately. I would have investigated. Really? One thing I've learned of doing criminal defense for such a long time is that weird stuff happens. Weird stuff happens in very stressful moments. I've had cases where I'm like, that couldn't have happened. No way. And then we find out stuff that corroborates it, that that's just the way it went down, like it or not. Okay. But I've actually even seen people say that these girls were somehow involved. That is probably one of the most disgusting things that somebody could say. And unless you have proof that is admissible in a court of law, you all should apologize to those young ladies for even thinking that. It's weird. I get it. But those were their friends. Do you think that they wouldn't have done something to help their friends out if they truly had known what had taken place? No. I find that hard to believe that they would not have done that. So everyone needs to stop bashing on these roommates. They're going to get subject to cross-examination. I'm sure Miss Taylor can take an easy approach with them. You didn't do this. You didn't do this. My guess, it depends on how they come across in the stand, if they're very credible or not. But push comes to shove. Maybe Miss Taylor will accuse these girls of being involved in some way, and you know the real killer or something along those lines, she can do that because she's got immunity in court. But guess what? She's still got to have some inkling of evidence to back it up. She must have a good faith basis for it to ask that question. I haven't seen anything to indicate that there is anything that would link these roommates to the death of their 4 friends. So unless you got some real evidence, not speculation, not conjecture, not some tinfoil hat craziness, then back it up with proof. And I'll be more than happy to listen to your proof. Maybe I'm wrong. I just haven't seen anything yet. Next, Luigi Mangione. Pennsylvania prosecutors defend the arrest of the United healthcare murderer suspect. That's right. The Pennsylvania prosecutors have declared that the arrest of Luigi Mangione, the man accused of the brazen murder of the United Healthcare CEO Bryan Thompson, that arrest and search was conducted lawfully and the evidence collected appropriately. Back in regards to his arrest in 2024, they're in Altoona, Pennsylvania. Now, Mangione, charged with first-degree murder, terrorism, stalking, and a host of other state and federal offenses, allegedly gunned down Thompson, the father of 2, on a Manhattan sidewalk back in December of 2024. Ultimately, Mangione then fled to Pennsylvania, and obviously, it looked like when you watched the video of allegedly Mangione shooting Mr. Thompson, that it was a targeted attack, an execution, one could say. Anyway, Mangione's arrest following a 911 call from a McDonald's manager in Altoona reported seeing someone resembling the CEO shooter from New York. And according to the court documents filed yesterday, the Altoona police, acting on a valid, reasonable suspicion, approached Mr. Mangione in full uniform and followed protocols during the encounter. The prosecutors emphasized that Mangione willingly engaged with officers, providing forged identification without any attempt to leave or disengage the conversation. The pleading states, quote, "The Commonwealth avers that the police at all times acted within the authority bestowed by law," the filing stated, underscoring the legality of the detention and the evidence collected. The document further clarified that Mr. Mangione's interaction with law enforcement were voluntary and no coercion was involved by the police. Mangione's case obviously has had a lot of intense scrutiny, with charges spanning multiple jurisdictions and raising questions about motives of the broader implications of such a high-profile crime. Now, as everything unfolds, police remain steadfast in their assertion that the arrest was a critical step in bringing a dangerous suspect to justice, and the trial is expected to be obviously closely followed. The state court, we may be able to see that if courtrooms are allowed. A federal case, probably not so much. It's going to be an interesting case. I don't think the police are going to have been found to have violated anything based upon everything that I've read thus far. But, you know, my opinion could change if something comes out at the motion to suppress hearing that will be held in the future. Next, an update on the Donna Adelson matter. She wants a continuance. Ladies and gentlemen, Donna Adelson, if you don't recall her, she is charged with first-degree murder, conspiracy, and solicitation in relationship to the 2014 death of her ex-son-in-law, Dan Markle. Now, she has pled not guilty. Once again, she's entitled to the presumption of innocence. And, well, she had court the other day, and her defense team is asking for a delay in her upcoming trial, which is supposed to begin on June 3rd. Now, the defense is seeking a continuance because they say they need more time to review new discovery that they obtained in the form of wiretaps and over 80,000 emails. They also told the judge that they are waiting on discovery that they're entitled to under the rules governing jailhouse informants that they have not yet received. This includes whether anyone who has given favorable treatment in exchange for testimony, as well as statements that the prosecution intends to elicit. Now, for those who don't recall this particular case, Markle was a law professor at Florida State University and was gunned down in his garage, which was eventually revealed a murder for hire plot. Adelson's son, Charlie Adelson, was convicted of hiring 2 hitmen to carry out the killing, and Charlie is currently serving life without the possibility of parole, and so is one of the hitmen in the case. The other hitman took a plea deal. An ex-girlfriend of Charlie, who served as the liaison between the Adelsons and the hitman is also serving life without the possibility of parole. And Donna was arrested 1 week after Charlie's conviction back in November of 2023. As you may recall, she was literally on the plane where, the extradition isn't so great. Needless to say, the courts found that she is a flight risk and she is not going to get a bond. Now, yes, the defense is completely entitled to all of this information, but once again, 80,000 emails. The defense has to move more expeditiously to get this stuff done. The prosecution may want a continuance just as bad as the defense, and the defense may be entitled to this. We'll let you know when the judge makes his decision on the motion to continue.
That's right. Another sealed hearing in the Bryan Kohberger matter. The court sent out a notice, which is weird because it's secret, but they're going to let everybody know that they're going to have a sealed hearing on May 5th, 2025 at 11:30 a.m. Well, what could it be? More than likely, it's probably some sort of scheduling matter. But maybe to set another hearing that won't be secret. Have a real problem with all this secrecy. I don't believe there is any basis for it. Everything that we have found out through these pleadings that have been released, it's not a big secret. But yet, you go back to the case of Chad Daybell and Lori Ballo, they acted like everything was in secret. The entire case was done in secret. Fortunately, Judge Hippler isn't going for that. Now, I believe that he is proceeding out of caution and saying, all right, let's kind of conduct this in private and see what it is. But ultimately, his orders are going to be released. So find out. Let's just find out. Why the secrecy? I don't get it. Like I said, you could walk into any courtroom any day and sit down and listen to the proceedings take place. You should be able to go find any public court file and see what is in the entire file. The press used to be entitled to all of this information, but they keep restricting everybody's access, claiming privacy, privacy, privacy. Well, I hate to say it, unless they're revealing your social security number or, your taxes, I get that, redact that. But everything else should be public. The public has a right to know how the prosecutors are doing. Is the defendant being treated fairly by the court? Are they receiving effective representation? Those are the things that everybody in the public is entitled to know. And this secrecy, it's just not right, ladies and gentlemen. Hopefully, it's just a scheduling matter. But the reality of it is, if it's just a scheduling matter, why is it being done in secret? I don't get it. It needs to stop, not only in this case, but all the other cases as well. That's all we have for today, ladies and gentlemen. Have a wonderful weekend. So we'll see you next time. And remember, the Constitution matters.